I don't know what more of no tolerance you don't get. Your device has been dead.
So Judge, I don't think it was low and then it went dead for, I think, a couple of days, but he didn't receive, well, I understand that, Judge, but he didn't receive, I guess the device supposed to send something.
You know when you're supposed to charge the device. You know.
I think it gives you a notice or something that is dying out. And so it didn't give him notice. So he went to pretrial service to have him check it out to find out what was going on with it. But he's been on bond for a very long period of time with no issues whatsoever.
Did you hear that? The judge is reminding him that good behavior in the past doesn't erase violations now. In bond cases, especially involving assault, even a dead battery can be treated as a serious risk. What do you think? Fair or too strict? Let me know in the comments.
That doesn't give you the justification to do what you're doing.
Judge, I will say that I contacted the device people over at 49 whenever he reported yesterday. They stated like
He only reported yesterday.
yes, we observed
Unacceptable. Unacceptable.
Well, no, Judge, he reported because I told him that the device, that this was filed. That's the only reason why he reported over there.
The only reason he cared enough to go was because you told him he had to come to court. Otherwise, it would still be dead. It would still be non-functional.
I don't think that's the case, Judge, because it's been functional the entire time that he's had the device. So this is not he's been out for 2 months and the device has not been functioning. That's not it. This was just filed 2 days ago.
Because I wanted to take care of it now. And the reason is that he's on probation for a violation of protective order, picks up an assault of a pregnant person, and then picks up another assault of the same person. And he has another assault dismissed, and they're all the same person. And I told you that there was no tolerance in these cases. And I have here that you have a dead battery since 2/10 of how long was the battery dead?
according to the viewer, I believe it started on the 10th, and then whenever he reported for
Yes, Judge, that's what I'm saying.
reported for inspection, we found no issues with the device itself or the charger.
Revoking your bond. You go to jail. I'm sorry. Bond conditions, bond conditions. There's no justification, right? 3 open cases. I've repeatedly told you, no tolerance, and you're just doing whatever you want to do. You're not charging it. Goes dead. So does the bond.
Here's the real issue. This isn't just a tech failure. The judge sees a pattern. Multiple assaults involving the same pregnant victim. The ankle monitor isn't just a gadget. It's proof he's following the law. When it dies, the court loses trust, and that can mean jail.
Judge, it went dead on the 10th, and he immediately went in to go have it checked out because he didn't know.
No, he didn't. 2 days later, because you said you got to come to court, it's probably a good idea for you to go get it checked out.
That's not how it happened, Judge.
Tell me.
When I got the email, I said, hey, there's an issue possibly with your device. He said, I got no notification whatsoever that it was dead, so I will go down there and check it out to see what's going on. I didn't tell him about a court date because I didn't know about the court date at the time. I got the motion first. Then your letter came after the fact. So he went on his own to have it checked out. So if you look at the records, I mean, he's been out for a while, and this just happened. 2 days, that's it, Judge.
They tell you that you're supposed to charge this thing on a daily basis. They tell you that you need to put it by the charger every day for a specific amount of time. And if you don't, the battery goes dead. So you know what you're supposed to do.
I understand that, Judge, but also if the court remembers that he is also keeping a newborn baby, so maybe he put it in. He was tired. I don't know.
It's been dead for 2 days.
It's only been dead for 1 day, I believe, Judge, because he went on the 11th, I believe. Today's the 14th.
No, she said yesterday he went. Today's the 14th. That's the
Today's
13th.
14th, I'm sorry, that was the 12th. I don't know why I thought it was the 13th.
So when did he go?
The 12th.
No, the battery goes dead on the 12th. When did he go to pretrial?
He went to pretrial on the 12th, Judge. His battery went dead on the 10th.
Oh, I'm sorry. Okay, battery goes dead on the 10th. Goes to pretrial on the 12th. So he's without a device 2 days. I'm sorry. Goes with you. Just not getting it. I don't know what to tell you, Ms. Jewett, right? There's just no justification. I have 4 kids. You know, it'll take me 2 minutes to put them in front of an iPad for me to go do what I need to do, to go wash the dishes, to go take the dog out, to change the litter.
Well, I understand, Judge, but I mean,
There's no excuse. You've got 3 open, very serious cases. And I told him at the outset when he picked up the last violation of protective order, there's no talk. I mean, you must comply strictly. And he's just not doing it.
just gonna just reset it for reconsideration on this bond, maybe 2 weeks, a month.
So here's the deal. You were right. These cases are ripe. They're old. And it's time to do something with them because the thing is, and what I've experienced is that when we take too long with cases, something invariably happens. You know, cases should only last so long because certain people need certain things. And when they're not getting it, they tend to fall in familiar habits. So
This is the turning point. The judge is done waiting. She wants the case resolved fast because long delays can lead to repeat offenses. Do you think speeding up the trial is the right move here? Comment below.
these are too ripe. Let me see how old these are.
And then if you remember, this case was actually transferred over to the,
Purity?
yes,
Right. Now I'm gonna keep it now, just because it's, yeah, just too much drama. So the violation case is 256 days old. The new violation case is 136 days old. Is discovery complete in both cases, please?
Yes, one confirm. Sorry, if last
The
name
newest case is discovery complete.
correct?
yes. And Judge, if you remember, you may not remember, but this is the case where the wife is saying that what occurred is not really what occurred. Remember, this is the toxic case.
And Judge, either way, discovery is complete on the case.
Okay. Do you have an offer on these cases?
On the most recent VPO, there is not. Let me see if
Yeah,
Can you please put an offer so we can?
I'll let DVD know that you are requesting that they put an offer on. Yes, Judge.
And is there an offer on the felony case?
On the felony case, Your Honor, let me see. There is not, Your Honor.
Because the problem, Judge, is they were supposed to be working on the fact that the wife came to court and told the prosecutor she's not participating. So they were going to reeval. That was 2 months ago.
If I may, they did offer him a 2-year deferred upstairs.
Oh, they did?
Yes, Judge, it's just in the notes, not in the actual, they're having a conversation about going back and forth with the defense attorney on that case.
Okay.
To see what they want to do.
So you're set up there 228, okay? We can set the day after if you'd like.
That's right.
Okay, and then what I would suggest is when we come back, it's, plea or trial time. So we can just put these babies to bed once and for all. And perhaps the felony court will, you guys can make a global resolution. I don't know, but it's, if I don't do what I'm doing now, I'm enabling. And I'm saying it's okay for you to do what you're doing without any consequence. And it's not. He has to understand that there's consequence. This is the 4th time. It's over and it's over and it's over. And I can't.
Understood, Judge.
And I understand that you have to zealously advocate. And I'm not begrudging you for doing it. Right. Certainly not. Of course not. But I can't continue to enable it. So, okay. You got it.